Good morning. I'm Kenyon McDuffie, at-large council member and chair of the council's Committee on Business and Economic Development. Today's Wednesday, June 28th, 2023, and we're convening this hearing in person and via Zoom. The time is now 10:10 a.m. and I'm calling this public hearing to order. Today, the committee will receive testimony on 4 measures: Bill 25-281, the Grace Covenant Church Equitable Real Property Tax Relief Act of 2023, Bill 25-126, the Life and Health Insurance Guarantee Association Amendment Act of 2023, Bill 25-150, the Motor Vehicle and Homeowner Insurance Prior Approval Rate Filing Amendment Act of 2023, and then finally, PR 25-261, the Launchpad Development 3DC LLC Revenue Bonds Project Approval Resolution of 2023. As a reminder, public witnesses will have 3 minutes to provide oral testimony and should remember to mute their microphones when they're not speaking. All public witnesses will have the same amount of time, which is 3 minutes. The first measure on the agenda is Bill 25-281, which I introduced on April 28th, 2023. It's the Grace Covenant Church Equitable Real Property Tax Relief Act of 2023. The bill was referred to the committee on May 2nd of this year. This bill will forgive real property taxes, interest, penalties, fees, and other related charges assessed against lot 0800 and square 4138, property owned by Grace Covenant Church for the tax years beginning October 1st, 2019 and ending September 30th, 2022. I'm actually going to call virtually the public witness for this measure, and again ask that whoever is testifying remember to mute their microphones when they are not speaking. All right, we have one witness for this measure, one public witness, I should say. That's Pastor Donnell Jones. Good morning to you, Pastor. It's great to see you. You can begin your testimony when you're ready. You have 3 minutes.
Good morning. Thank you. Good morning, Chairman McDuffie and council members. As a native Washingtonian, I thank you for your commitment to our great city. Thank you for the work you do, the weight you bear, and the welfare of each citizen for whom you serve. As lead pastor of Grace Covenant Church, Brooklyn, I thank you for this public hearing and pray you grant GCC real property tax relief retroactively. For nearly 25 years, GCC has served our city from unique spaces. Beginning with a committed team in Brooklyn, we have been on the move, leasing public schools, YMCA, and Regal Cinema Gallery Place for public worship and service. In October 2019, we celebrated our 20th anniversary with the purchase of the existing church property located at 3100 18th Street, Northeast Washington, D.C. As of February 7, 2020, we were back in full swing in Brooklyn, serving for the first time in newly acquired property. Also for the first time, 18 months later, in April 2021, GCC received notice of real property taxes. Immediately, we contacted the Office of Tax and Revenue, OTR, and informed them that we are a 501c3 organization exempt from property taxes. OTR informed GCC that it must file the FR 300. Due to a professional oversight, the FR 300 was not filed subsequent to settlement. Together with the help of legal counsel, GCC's FR 300 has been filed and approved. However, the exemption only covers taxes from January 1st, 2022, the date the exemption was granted going forward. We have been assessed $133,156 in back taxes. Today, GCC respectively requests that the council recognizes GCC as a tax-exempt organization retroactively to the inception of GCC and hereby provide full relief of all pending taxes, fines, and penalties. Our city, just as our country, exempts churches from paying property tax. On January 14th, 1924, the U.S. Supreme Court interpreted the reason for the exemption in Trinidad versus Sagrada Orden. Evidently, the exemption is made in recognition of the benefit which the public derives from churches' corporate activities. We are deeply committed to the work of serving our city. We do not regard the weight lightly. We are concerned for the welfare of the people of our community. Just one weekend last September alone, our family of congregations engaged the DMV with 673 volunteers for a total of 3,179 hours of service, providing $210,000 to various organizations, including $20,000 to Little Lights, $10,000 to 5D Metropolitan Police Department, community service in the form of Brooklyn Backpacks, Health and Fitness at Turkey Thicket, Franklin Commons in partnership with so others might eat, for job training opportunities, among other activities, all at no cost to the community. It is our earnest prayer that GCC will continue to contribute much needed service, prayer, and opportunities to the residents throughout the city, and this retroactive tax exemption will enable us to use our current resources to that end. I'm truly hopeful. Thank you.
Thank you, Pastor Jones. I only have just a few questions. Just you touched on some of this already, and I'm very familiar with you and the work that Grace Covenant Church does in the community. Really appreciate your presence and all that you do, not simply inside of your church, but outside of your church as well. And I think it just bears repeating, if you could, to talk about on the record what would happen to your church if this tax relief is not granted.
What will happen if it is not granted?
Yes.
Yes. If this tax relief is not granted, we will be assessed as a church real property taxes in the amount of $133,156. That would significantly impair a number of things. Our ability to serve the community with those resources, as I've just described. We've given support, as I mentioned, to 5D, Metropolitan Police Department, and other groups. But it also impinges on our ability to purchase property and to expand our footprint in DC. Number one, when banks look at our ability to make purchase, they recognize that this is an issue. And if those resources are not available, those monies are not there to go toward the purchase of property. So the impact is significant in at least two ways. One, our current service to the community and how we use those resources. And secondly, when financial institutions look at our finances, they see that as an issue with regard to them making loans and lending to us so that we can expand.
I appreciate that. And just if you could talk a little bit about, if this relief were to be granted, what you hope the church would accomplish over the next several years. And I'd like to sort of contextualize that question with a little bit of history in terms of just how many churches that used to exist in the District of Columbia have since closed their doors, maybe sold their properties and relocated in the suburbs around the city, or perhaps are no longer in existence. What does it mean for you and your church and your congregation to be able to have property in the District of Columbia?
Thank you for your question. GCC Brooklyn is committed to serving the city. We love DC, all of it. We love Brooklyn, where we have been serving proactively at our inception and now since returning with the purchase of this property. As you know, Councilman, and many others, in 2020, we had our first service in February of that year. And 1 month later in March, we were not able to meet publicly. We had to go completely virtually. Our church is very grateful to God that during COVID, we were able to continue as a church. There are so many churches that are no longer here, that have lost their property and are no longer providing a valuable benefit to the community. And that is quite a hardship for our city. Our city has great needs, and there are so many wonderful organizations that provide to meet those needs. Our church in particular serves Brooklyn. During COVID, even though we couldn't meet in our facility, we met with the neighbors. At Christmas, we went caroling through the neighborhoods and offered prayer for people. People came to tears weeping at their door, thanking us for being in the community and thankful that we came up. There were so many people who went without food, went without clothing. And so on our church steps, right there on 18th Street, people would come as we, on Saturdays, weekends, different scheduled moments, provide food. We had bags already there for them to take and walk away. We provided one outreach where we did haircuts and health needs. And as I mentioned, we had a partnership with So Others Might Eat, So job training for people who are unemployed, having that presence in that community provides a vital need for people who are in that community who have needs that sometimes go unmet. But because the church is there, it's able to meet those needs, not only physical needs, but also spiritual needs. Chairman, the number of people who came up and said, thank you for the food, and who would begin to weep. And we just say, can we pray for you? Can we pray for your family? Some of those people have continued and have now come and become part of our church. Reaching the area schools, the elementary schools, the high schools. We have a relationship with a number of high schools that we serve, a number of youth in the community, student athletes that we're reaching. So our impact is significant. And now we're both virtual and physical. So I cannot begin to imagine what our city would be without the church. And ours is one of many congregations that serves God and serves his people out of a heart for God and a love for the people. So if we were not here, there are too many testimonies, too many stories that would not be told of how good people were served by the church. Instead, we'd have more tragedies, more people saying, no one was there to help us. The church was absent. They did nothing. I'm glad that our church is not just restricted to the four walls, but we live outside the community. We're one of the few organizations, the church at large, that exists for non-members. How do we serve the city for God and have an impact that is transformative? And we are, at this rate, one of 6 congregations. 2 happen to be in DC, one on Capitol Hill, one in Brooklyn. And every 18 to 24 months, we are establishing a new congregation in DC until we have at least one in each of the 8 wards. And after we've done that, we will go back and put another congregation in each of the 8 wards. So acquiring property is essential for us to have a base, a facility from which we can serve the community.
Okay, I appreciate that, Pastor Jones. Thank you for your testimony. I'm going to now turn to our next witness, our government witness, Rick Liu, who's a senior policy analyst within the Office of the Chief Financial Officer, who is also joining us online. Welcome back to the committee. We're going to turn to you, but before we hear from you, it's the practice of our committee to swear in all government witnesses who appear before it. So if you don't mind raising your right hand to be sworn in. Do you swear or affirm on the penalty of law that the testimony you're about to provide before the Council of the District of Columbia and the Committee on Business and Economic Development is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you very much. Good morning again. You can begin your testimony.
Good morning, Chairman McDuffie and members of the Committee on Business and Economic Development. I'm Rick Liu, a senior policy analyst in the Office of the Chief Financial Officer's Office of Finance and Treasury, or OCFO. I am pleased to testify for the OCFO on Bill 25-0281, the Grace Covenant Church Equitable Real Property Tax Relief Act of 2023, or known as the bill. The bill would provide real property tax forgiveness to the Grace Covenant Church with respect to the church's property in the Brookland neighborhood located at 3100 18th Street Northeast, known for tax assessment purposes as Square 4138, Lot 0800. The bill would forgive all real property tax, penalties, interest, and other related charges assessed against this property for tax years 2020, 2021, and 2022. The applicant, Grace Covenant Church, is a non-denominational church that assembled and worshipped in rented facilities until it purchased its current church property in October 2019. This property had a real property tax exemption when it was owned by its prior owner, but this exemption ended once the property was transferred to Grace Covenant Church. Grace Covenant Church did not file its own application for exemption, mistakenly expecting that the exemption would continue after the change of ownership. Instead, the property went into a taxable status on the ownership transfer. After receiving a tax bill in the summer of 2021, the applicant filed an application for exemption from DC real property tax, or Form FP 300, in December 2021, and the exemption on the property was approved and went into effect in January 2022. However, there remains unpaid real property tax liability on the property from tax year 2020 through a portion of tax year 2022. The OCFO has reviewed the applicant's non-audited financial statements over its past 3 fiscal years, FY 2020, FY 2021, FY 2022, as well as the financial information on the church property, such as its mortgage note and its most recent appraisal. Information provided indicates that the applicant's operating revenue has declined over the past 3 years, largely due to lack of in-person services as a result of COVID-19, which has reduced its member contributions, requiring Grace Church to dip into its emergency reserve in FY 22 to cover expenses. Its current level of unrestricted assets already represents less than the level of emergency reserves typical of most churches, and paying off the tax liability would further exacerbate the applicant's financial situation. Furthermore, the applicant is unlikely to extract its equity from the church property as a means of covering the tax liability, as they would be challenged to refinance given their unstable annual income over the past 3 years and the estimated value from the property appraisal. For these reasons, OCFO finds that the forgiveness provided in the bill is necessary for Grace Covenant Church to meet its fiscal and operational needs. The value of the forgiveness is $133,156 during the financial plan period. This represents the cumulative amount of unpaid real property tax liability, penalties, and interest incurred on this property during tax years 2020, 2021, and 2022. And I will actually also say it will be additional interest accumulated through what we expect to be at the end of FY 2023. Thank you for the opportunity to testify. This concludes my testimony, and I'm happy to answer any questions you may have at this time.
And thank you very much for your testimony. This is a pretty straightforward measure, and I think the tax abatement financial analysis really lays out the case for why this needs to move forward. And your testimony, I think, reiterates the findings of the TAFA analysis. I will just ask a couple of questions just to make sure that it's clear on the record. The tax abatement financial analysis noted that the church's financial reserves were 2.5 months of its expenses, and that if the church were forced to pay the tax liability, it would cut its reserves in half. What are the recommended reserves for an organization like Grace Covenant Church, generally speaking?
Sure. Well, I mean, for typical for churches, we've seen something between 3 to 6 months is sort of the ideal.
Okay. And you, the office also concluded that without this tax relief, and I'm quoting here, it would be a hardship for the applicant to cover its ongoing operating expenses and debt payments while maintaining an adequate emergency reserve. Could you, close quote, could you explain what you requested from the applicant and examine in coming to your conclusion there?
Sure. The information we requested was their audited financial statements and identifying the line items that were really their unrestricted sort of discretionary reserves. I think they represented, I think, as I said in the TAF, the 2.5 months with the tax liability, that would be cut in half. So already it was probably a little bit less than the typical recommended amount. And then I think compounding that was also the fact that the net income over the past 3 years has sort of declined. So it's possible, just as Pastor Donald said, with less reserves and with sort of unstable operating expenses, it certainly curtails how banks see the organization for future lending, but depending on how net incomes move, it's possible they may need to also sort of look at ways to reduce expenses.
And what's the total value of the forgiveness during the financial planning period?
It is $133,000 and 156.
And you all found that this. Go ahead.
That was it.
Okay. And you all found in your TOF analysis that the forgiveness in the bill is necessary for Grace Covenant Church to meet its fiscal and operational needs?
That is correct.
Okay, and the $133,156, to your knowledge, is that amount already funded in the financial plan and budget that the council recently passed?
It is our understanding that that has already been funded.
Okay, I don't have any additional questions. Anything else you'd like to add to the record before we move to the next measure on the agenda?
No, I don't, Chairman.
Thank you very much for your time and testimony. We're going to turn to the next measure on the agenda now, which is Bill 25-126, the Life and Health Insurance Guarantee Association Amendment Act of 2023, which was introduced by Chairman Mendelson at the request of the mayor on February 8, 2023. The bill was referred to the committee with comments from the Committee on Health on February 21st, 2023. Bill 25-136 would add health maintenance organizations as member insurers and make life insurers subject to assessments relating to long-term care insurance. It would modify the size of the board of directors for the Life and Health Insurance Guarantee Association and authorize the filing of certain actuarially justified rate or premium increases. The bill also repeals insolvency provisions in the Health Maintenance Organization Act of 1996. I'm going to call first any public witnesses that we have who signed up to testify. If we could have Beth Hoffman, Executive Director for the District of Columbia Life and Health Insurance Guarantee Association, Wayne Melman, Senior Counsel with the American Council of Life Insurers, and Thomas Glassick, Executive Director for the DC Insurance Federation. And just as a reminder, each of the witnesses will have 3 minutes to provide oral testimony, and we highly encourage witnesses to also provide their written testimony if they haven't already done so in advance of today's hearing. We're going to begin first with Beth Hoffman, who is joining us virtually. Good morning to you. Thanks for being here with us. You can begin your testimony.
Good morning, and thank you. My name is Beth Hoffman, and I am the Executive Director of the DC Life and Health Insurance Guarantee Association. On behalf of the Board of Directors, I'd like to thank you for the opportunity to provide testimony for your consideration of Bill 25-0126, the Life and Health Insurance Guarantee Association Act of 2023. The Board of Directors would like to express its support for the adoption of the proposed amendments to the Associations Act. Since the NAIC adopted amendments to the Life and Health Insurance Guarantee Association Model Act in 2017, 40 states have amended their statutes to conform to the Model Act changes. In order to maintain functional consistency with the NAIC model and the 40 states amending their statutes since 2018, including Virginia in 2018 and Maryland in 2020, the Board of Directors of the DC Life and Health Insurance Guarantee Association supports Bill 25-0126. Again, on behalf of the board, I'd like to thank the committee for the opportunity to provide this statement of support, and this concludes my testimony.
And thank you for your testimony this morning. We're going to turn next to Wayne Melman. Good morning to you, and you can begin your testimony.
Good morning, Mr. Chairman, and thank you. My name is Wayne Melman, Senior Counsel at the American Council of Life Insurers. ACLI appreciates the opportunity to offer comments in support of Bill 25-126, the Life and Health Insurance Guarantee Association Amendment Act of 2023, which would enact into law many of the 2017 revisions to the NAIC's Life and Health Insurance Guarantee Association Model Act. These revisions would help ensure that the DC Life and Health Insurance Guarantee Association, which was created to protect consumers and act as a safety net in the event of an insurer insolvency, remains stable, fair, and sustainable with sufficient assessment capacity. To date, 40 states have updated their Guarantee Association statutes to substantially incorporate the Model Act revisions. The bill contains 2 key provisions. First, it would add HMOs as member insurers to the DC Life and Health Insurance Guarantee Association, thus expanding the assessment base in its health account. It would also provide Guarantee Association protection for HMOs that become insolvent that does not exist today. The significant differences that existed between commercial health insurers and HMOs that led to HMOs being initially excluded from the guarantee associations no longer exist. HMOs now compete actively in the health coverage marketplace. In fact, most commercial health insurers now have HMO platforms. Consumers deserve the same coverage protections regardless of which health plan they or their employees choose. Second, the bill would split future long-term care insurance-related assessments equally between the Guarantee Association's life and health member insurers. Under the DC's current Guarantee Association law, only the health account is assessed for long-term care-related insolvencies. As a result, health insurers shoulder about 80% of long-term care-related assessments, and life insurers that hold a health insurance license absorb the remaining 20%. This approach is unsustainable because it's inequitable for health insurers to shoulder most of the long-term care-related assessments, since long-term care insurance is primarily sold by a small number of life insurers, and there may be insufficient assessment capacity in the Guarantee Association's health account to absorb another significant long-term care insurance insolvency like the one that occurred in 2017. In addition, in order to ensure that the revisions of Bill 25126 only apply to insurers who are placed into liquidation on or after the bill's effective date, we request that certain language be added at the end of the bill relating to applicability, and that states the provisions of this act shall apply to all matters relating to any impaired or insolvent insurer for which the association first becomes obligated on or after the effective date of this act. Thank you for allowing me to testify before your council today. Thank you.
And thank you very much for your providing testimony this morning. Our third and final public witness is Thomas Glassick, who's joining us in person today. I want to thank you for joining us here in person today. It's good to see you, and you can get in your testimony.
Thank you very much, Mr. Chairman, members of the committee. I am not going to be able to repeat as quickly as Gary did all of the details about the legislation, so I'm not going to read my written testimony to you because I've been on the other side of this, and it's no fun when people read written testimony. The DCIF is here to be wholly supportive of the ACLI and the Life and Health Guarantee Fund Association in robust support of moving this forward. We would like to thank the committee and the committee staff for moving this quickly in this year. We, as you remember, last council period, this kind of languished for a little bit. So we are appreciative of the focus that insurance is getting in this new council period, and I'll be here to testify on the next bill. But certainly happy to answer any questions you have.
Yeah, I may have some more questions for you on the next bill. This one, it seems to be pretty straightforward. It seems to have pretty solid support. Just if there's anybody at home watching though, and obviously, if they're experts, they follow this stuff closely, but if they're not, which a lot of people are not experts on these types of issues, they may be asking themselves whether district residents with long-term care policies have any reason to be concerned with the risk of insolvency for any existing coverage, for any existing long-term care providers. What might you say to anybody who might be wondering about that?
My parents, who just live 20 miles north, have long-term care policies, and they ask me this all the time. So what I will say is, if you have purchased in and you've been paying for a long time, and those premiums start to go up. My parents are 85 and 88 now. And every now and then they're like, "Oh, this is a big number." I'm like, "Mom and Dad, I'll pay it if you don't want to." Because once you're in the system, and you've been paying, and long-term care is harder to get these days than it was 20 years ago. I would definitely recommend people to continue paying if it's at all possible, to the extent to which there might be any insolvencies in the marketplace, which is not indicated at this time. This legislation firms up the Guarantee Fund Association to be able to cover losses in the event there is an insolvency. So,
any other recommendations though for district, for our city regarding the regulation of long-term care insurance carriers or policies, separate from what we're dealing with today with this measure?
I struggle because the life and health the life and health actuary is sitting 5 feet that way, and he understands this much better than I do.
I think he understands this better than all of us. So.
I would just say that this is a valuable product that people need to consider and get involved with earlier in their working life, if at all possible. I know that a lot of government employees have access to this through their benefits program. That's how my parents got into it. through government benefits program, and it's something that people should absolutely consider as they're looking toward their retirement and they're doing responsible retirement planning.
All right, well, I don't have any other questions. Is there anything else that either Beth Hoffman or Wayne Melman want to add to the record before we move to our government witness? Thank you both for joining us online to provide your testimony. We're going to turn next to our government witnesses, and we have Sharon Shipp, Deputy Commissioner, Market Compliance, Department of Insurance, Securities and Banking, joining us virtually. I think we have some others who may be providing testimony. But before we get to your testimony, it is the practice of the committee to swear in government witnesses who appear before it. So if you could raise your right hand to be sworn in. Do you swear or affirm under penalty of law that the testimony you're about to provide before the Council of the District of Columbia and the Committee on Business and Economic Development is the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. And you can begin your testimony. If you can speak up a bit, I'm having a little trouble hearing you.
Okay. Good morning, Chairman McDuffie, committee members, staff, and district residents. I am Sharon Shipp, the Deputy Commissioner for Market Compliance with the Department of Insurance, Securities and Banking, also known as DSB. I appreciate the opportunity to testify today in support of B 25-126, the Life and Health Guarantee Association Amendment Act of 2023. DSB regulates the insurance, securities, banking, and other financial services entities doing business in the District of Columbia. Our mission is threefold. One, to cultivate a regulatory environment that protects consumers and attracts and retains financial services firms to the district. Two, empower and educate residents on financial matters. And three, provide financing for small businesses. We accomplish this by effectively regulating the district's financial services industry to ensure district residents have access to a wide array of financial services, products, and providers. We also work to sustain a district business climate that encourages fair and open competition. Bill 25-126 amends the Life and Health Guarantee Association Act of 1992 in several ways. First, under current law, in the event of an insolvency of a long-term care insurer, health insurers are assessed by the Life and Health Guarantee Association. The assessments are used by the association to provide the benefits owed to the insolvent insurer's policyholders up to the limits set forth in the statute. When long-term care insurance products were developed several decades ago, they were considered health insurance products. However, health insurers do not sell long-term care insurance. Instead, long-term care insurance is sold by life and annuity insurers. DSB, working with fellow insurance regulators through the National Association of Insurance Commissioners, recognized this discrepancy and revised the Life and Health Guarantee Association Model Act to require life and annuity insurers and accident and health insurers to share the assessment burden equally. Second, the bill would expand the definition of member of the Life and Health Guarantee Association to include health maintenance organization. This change will require HMOs to contribute to the assessment process in the event of an insolvency of a long-term care insurer. Third, the legislation repeals the insolvency provisions in the Health Maintenance Organization Act of 1996. Instead, insolvent HMOs will be subject to the insolvency process set forth in the Life and Health Insurance Guarantee Association Act. And finally, the bill would expand the number of members of the association's board of directors from no fewer than 5 and no more than 9 to no fewer than 7 and no more than 11. The amendments are necessary to equitably distribute the burden of future insolvencies among life and annuity, accident and health insurers, and health maintenance organizations, ensure consumer protection, and support the stability of the health insurance market. 40 states have adopted the same or similar revisions to their life and health guarantee fund laws, and we encourage the council to do so as well. Recent insolvencies of long-term insurers and others that are in financially precarious condition have exposed the shortcomings of the life and health guarantee funds, which are costly for consumers and the markets. Thank you, Mr. Chairman, for the opportunity to testify, and I look forward to answering any questions you may have.
And thank you for providing your testimony. I do have a few questions for you that I'd like to ask at this time. You actually just mentioned toward the end of your testimony, and I wanted to find it. You mentioned that recent insolvencies of long-term insurers and others that are in financially precarious condition have exposed the shortcomings. And I want to start there. Are there insurers who are current members of the Life and Health Insurance Guarantee Association at risk of insolvency?
Well, what I can say is that in the last 6 years, we had one of the largest health long-term care insurance insolvency. And just by way of example, as I mentioned that insolvencies are costly, the insurer had obligations of $4 billion and only had assets of $7 million to cover the claims. And so the Guarantee Association had to pay $3.3 billion. And health insurance companies had to pick up the bill. And of course, much of that is passed on to consumers. And so we believe that this is a bill that is geared toward consumer protection and also for the stability of the insurance market.
Now, the bill pending in the committee modifies the Model Act that is used in many other jurisdictions. If you could talk a little bit about any sort of district-specific changes made to the model bill. Are there any things that are changes made specific to the District of Columbia that you want to talk about?
Yes. So as mentioned by the public witnesses, the bill is amended to include HMOs. Under the current framework, HMOs are not members of the Guarantee Association, and they're not assessed. As we mentioned, the health insurers pick up the large bulk of the burden as it relates to assessment. And so this is an opportunity to rebalance that and to evolve the current structure to include the HMOs and life insurers.
And to your knowledge, we had 3 witnesses who testified this morning. I'm sure you heard their testimony, but have any insurance carriers expressed opposition to the bill, to your knowledge?
So, Mr. Chairman, as you mentioned, the bill has overwhelming support from the Life and Health Guarantee Association, as well as from the industry. I am aware that there is one insurer that voiced opposition in other jurisdiction, but to my knowledge, that particular insurer has not voiced any opposition to DISB on this particular bill.
Got it. Okay, I appreciate you putting that on the record. The American Council of Life Insurers recommended in their testimony a clarifying change regarding the applicability date in the bill. Do you have any reaction or any comments on that recommendation?
I would only add that DISB is in support of the proposed language submitted by ACLI.
Okay. Just, I guess finally, if you could, again, just for people who might be at home wondering, will these changes that are proposed today to the Life and Health Insurance Guarantee Association create a more stable insurance market for those who have and need long-term care insurance? And are there any additional changes that you think are required?
What I would say is the state guarantee funds were created at the state level. And they're funded via payments from the insurers doing business in that state. And so to cover consumer insurance claims and provide critical consumer protection. DISB believes that the best way to ensure continued consumer protection particularly for our seniors, so that they can access the benefits when they need them, is to pass this bill, is to support this bill.
Okay. And just, are there any currently, to your knowledge, long-term care insurers who do not provide coverage in the District of Columbia because we have not enacted the changes in this measure?
I'm sorry, could you repeat the question?
Sure. I asked whether there were currently any long-term care insurance that you're aware of, any insurers who currently do not provide coverage in the District of Columbia because we have not enacted the changes in this measure before the committee.
No, I'm not aware of that, but I would have to check with my team and I could get back to you on that.
Okay, that's fine. You have anything else you'd like to add to the record before we transition to the next measure?
Nothing else except to say thank you, Mr. Chairman. I ask for your support on this common sense bill that will offer consumer protection and stability to our insurance market.
Thank you very much for your testimony.
Thank
The
you.
next measure on the agenda today is Bill 25-150, the Motor Vehicle and Homeowner Insurance Prior Approval Rate Filing Amendment Act of 2023, which was introduced by Chairman Mendelson at the request of the mayor on February 23rd, 2023. The bill was referred to the committee on March 7th of this year. This bill would change the motor vehicle and homeowner insurance rate filing standard to prior approval with a 90-day deemer. It will require a hearing before a rate filing is determined to be excessive or discriminatory. The bill would also require insurers to provide policyholders 60-day advance written notice of any rate increase of 10% or more. I'm going to call our sole public witness for this measure, who we just heard from on the prior measure. Thomas Glassick again is joining us in person. He's Executive Director for the DC Insurance Federation. Welcome back, and you can begin your testimony.
Thank you very much, Mr. Chairman. To move quickly forward, we have had a really positive interaction since this bill was filed back in February. Your staff has been wonderful. It's kind of how government should work, to be honest. Being able to balance both sides of the conversation. The department has been very cooperative. So unless you'd really like me to talk through the amendments that are already included in the temporary, I'll just jump to the one outstanding conversation that we're having with DISB. Okay?
Sounds good.
There is one sentence in the operative notice section of the bill, so section C, that says that if an insurer fails to provide this notice 45 days in advance of renewal, then the insurer can't do that rate increase until the next renewal. I get the point. I understand that people, insurers should be complying with this. And if they don't comply, the department has market conduct exam processes that would identify if this was an endemic problem with a particular insurer, and they could penalize that insurer. I feel strongly, and I do it in every line of insurance I deal with people. People should know what the risk is as soon as they're as soon as their rates are set. And I don't think it's to the benefit of DC residents to, if there's a computer glitch and it goes out 42 days in advance, that it's another year and a half, 2 years before they see what their rate is really going to be. I believe that the department does not oppose that change, but they're certainly not supporting it. I just think this is a complete insurance nerd point. This belongs in market conduct, not in statute. And other than that, we have had a very, very positive. But the other thing I do need to note, the reason my letterhead looks different on this testimony than the last one is that this is joint testimony with the American Property Casualty Insurance Association and the National Association of Mutual Insurance Companies. Together represent the overwhelming majority of people writing both the motor vehicle and homeowner policies here in the District of Columbia.
And have you had, and thank you for your testimony, have you had the opportunity to discuss that one outstanding provision that you mentioned, where your testimony on page 2 says that the joint trade strongly believe that the following sentence should be stricken from subparagraph C? Have you all had the occasion to chat with the Department of Insurance, Securities and Banking about your position on this? And if so, what have you heard in response?
This has been inconsistent from the beginning. One of the things that we flagged that we didn't think this belonged in the legislation. The department has listened and seems to understand the point. I cannot speak for the department, but they're going to speak for themselves in a minute. But it's been a positive interaction. I think both sides understand each other. I don't believe that the department's interested in altering the legislation that it asked the council to pass. I don't know if that answers your question or.
No, it does. I mean, I'll certainly ask about it, and Mr. Barlow's here, so we'll hear from the department next. But I did at least want to give you the opportunity to put on the record your understanding of the department's position based on the communication that you all have had.
Yeah, I'm fairly certain that this is not a hill either side is going to die on.
Okay. Well, I appreciate that, and I appreciate your testimony. As you noted, we have your full written joint testimony, which should be incorporated to the record. And it seems like we're going to probably hone in on this one provision here. So thank you for that.
Great, thank you.
Next, we're going to hear from Philip Barlow, Associate Commissioner, Insurance Bureau, Department of Insurance, Securities and Banking. And before you get comfortable with getting testimony, I want to ask you to raise your right hand so I can swear you in. Do you swear or affirm on the penalty of law that the testimony you're about to provide before the Council of the District of Columbia and the Committee on Business and Economic Development is the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. Good morning to you. You can begin your testimony.
Thank you. Good morning, Chairperson McDuffie, committee members, staff, and district residents. I am Philip Barlow, the Associate Commissioner of the Insurance Bureau within the Department of Insurance, Securities, and Banking. I appreciate the opportunity to testify today in support of Bill 25150, the Motor Vehicle and Homeowner Insurance Prior Approval Rate Filing Amendment Act of 2023. DISB regulates the insurance, securities, banking, and other financial service entities doing business in the District of Columbia. Our mission is threefold. First, to cultivate a regulatory environment that protects consumers and attracts and retains financial services firms to the district. Second, to empower and educate residents on financial matters. And third, to provide financing for small businesses. We accomplish this by effectively regulating the district's financial services industry to ensure district residents have access to a wide array of financial services products and providers. We also work to sustain a district business climate that encourages fair and open competition. By way of background, Bill 25150 was enacted on an emergency basis by the council. After the enactment of the emergency bill and prior to the enactment of the temporary legislation, DISB proposed changes to the bill which were accepted by the council and included in the temporary legislation. Bill 25150 as revised would amend the act to provide for the regulation of certain insurance rates in the District of Columbia by prohibiting insurance companies from implementing rate increases for private passenger or homeowners insurance immediately upon filing the request for the rate increase with the commission. Upon enactment, the commissioner will have 90 days to determine if the rate increase is excessive or not actuarially justified based on commonly accepted actuarial principles. If the commissioner determines within the 90-day review period that a private passenger or homeowner's insurance rate increase is excessive or unfairly discriminatory, the commissioner may deny the requested rate increase and the insurer will have the ability to request a hearing. If the commissioner fails to decide upon a proposed rate increase within the 90-day period, the rate increase shall be deemed approved. Replacing the previous file and use standard with a prior approval standard will enable the commissioner to carefully consider all rate increases to ensure that they are actuarially justified prior to implementation. In addition, beginning on September 1st, 2023, or such later date as determined by the commissioner, insurers writing private passenger and homeowners insurance will be required to provide written notice at least 45 days and not more than 90 days before the renewal of a policy. An insurer that fails to provide at least 45 days written notice before the end of the current term of the policyholder's policy shall be required to wait until the end of the subsequent term of the policyholder's policy to implement the rate increase. This change will give policyholders facing an increase additional time to shop for replacement coverage. These changes have been implemented in several other jurisdictions and have been beneficial to policyholders. Thank you for the opportunity to testify, and I look forward to answering any questions.
Thank you for your testimony, Associate Commissioner Barlow. I do have a couple of questions. And okay, so both the department as well as my office have heard from DC residents about motor vehicle rate increases. And so I want to ask you, has the agency heard from DC residents about homeowner rate increases?
We do get complaints on homeowners insurance as well. We don't get as many of those as we do on auto insurance.
Okay. But you have heard from some residents about it.
Yes.
Less common than the motor vehicle rate increases. Got it. The committee heard from a public witness who recommended that we strike part of subparagraph C because their belief is that DISB has the regulatory authority to enforce and penalize those not complying with the 45-day written notice requirement. Does the department have that authority?
So while again, the department supports retaining that provision in the law, we do believe that if that were struck, we would still have the ability to enforce that requirement on insurance companies should they miss the 45-day deadline and would likely do so, whether or not that provision's in the law. But just for clarity, you know, our belief is that we would like to see it retained.
Okay, you'd like to have the provision retained, but even if it were stricken, you believe that you all would maintain existing authority to be able to enforce?
Yes.
Okay. And you said in your testimony that these changes have been implemented in several other jurisdictions and have been beneficial to policyholders. The changes that have been implemented in several jurisdictions and have been beneficial to policyholders include the provision that we're referencing here, that the joint testimony from the DC Insurance Federation, and I'm blanking on the other organization, but it's your belief though that that the changes that are part of that provision have been implemented in some other jurisdictions?
I am not aware of that specific provision being implemented anywhere else. The things that have been implemented are other states are moving from a prior approval approach to, or sorry, from a file and use approach to a prior approval approach, and identifying specific timeframes for sending out renewal notices.
Got it. So back to that provision, if that provision were to be removed, if you could, let the committee know here today how DISB would enforce, how would you penalize those who don't comply?
Well, again, generally speaking, we would, I'll use an example.
Okay.
Right now, we have a notice requirement for cancellation. If an insurance company fails to provide the cancellation notice in time per the law and regulation, we tell the insurance company that they cannot cancel that policy. We don't have that specifically in the law that says you can't cancel a policy if you fail to meet that requirement. But that's when, when we come across those things, that's what we tell the insurance companies. They need to maintain coverage because they failed to comply with the requirement in the law. So we believe we have that ability to do that on the same basis when those situations are brought to our attention. And if we find that an insurance company, if we're seeing that on a non-sporadic basis from any one insurance company, then we would very likely, as was mentioned previously, conduct a market conduct examination on the insurance company that would give us the ability to take other actions against the company, including fines.
Okay. The temporary measure that's already been passed by the council allows the commissioner to begin enforcing the 45-day written notice requirement on September 1st, 2023, or a later date. Does the commission plan to enforce the law on September 1st of this year as contemplated in that temporary measure?
Currently, that is our position. We have heard from some in the industry that they may have trouble meeting that time frame. We have asked for specific information from the companies, what the reason is they can't make the September 1st deadline, what they're doing to do that, what deadline they would request after that. So, but we have not, we just made that request, I think, in the last week or so upon hearing generally that they're having issues. So it's currently our intention to use the September 1st date. But if we get reasonable, credible information that it might take them a little bit longer than that to implement it, then the commissioner might at that point exercise the authority. But again, we have not seen anything specific at this point.
Okay. Okay. And finally, does the department support the committee incorporating the temporary changes into the committee print? And as a reminder, those 4 changes are to 1, limit the motor vehicle provisions to only private, non-commercial motor vehicles. 2, change the customer notification requirement from 60 days to 45 days prior to renewal, and applies this to all renewals, not just those with a 10% or more increase in an existing premium or rate. 3, allow DISB to set the applicable date for the legislation's written notice provisions after September 1, 2023. And 4th, limit DISB review to rate changes instead of rate and premium charge changes.
Yes.
Okay. Very short answer to a very long question, but I appreciate it. Thank you for your efficiency. I don't have any additional questions on this measure at this time. Is there anything else that you'd like to add to the record?
No, but we appreciate you making the effort to do this on an emergency, temporary, and permanent basis. We think that this will enable us to review all of the rates filed before they are implemented, and so I think it will benefit the consumers in the district.
Great. Thank you for your testimony. Appreciate it. We're going to turn to the last measure on our agenda for this particular hearing. and that's PR 25-261, the Launchpad Development 3 DC LLC Revenue Bonds Project Approval Resolution of 2023, which was introduced by Chairman Mendelson at the request of the mayor on June 2nd, 2023. The bill was referred to the committee on June 6th of this year. The resolution would authorize the issuance, sale, and delivery of tax-exempt revenue bonds, notes, or other obligations in aggregate principal amount not to exceed $32 million to assist Launchpad in the financing, refinancing, or reimbursing of costs associated with an authorized project in Ward 5 pursuant to Section 490 of the District of Columbia Home Rule Act. I'm going to call up the public witnesses for this resolution. We have Sean Glenn, partner at Ant Farks, and Ben Carson, Executive Director, Launchpad Development. And they're both joining us virtually. Good morning to you both. Thank you for joining us. Who's providing testimony? Are you both providing testimony this morning? Okay.
I think just
All
me.
right. Let me get your testimony. Thanks.
Good morning. Thank you for having me. My name is Ben Carson. I'm the Executive Director of Launchpad Development, as stated. Launchpad's the real estate team that supports Rocketship Public Schools DC, which operates the Rocketship Infinity Community Prep campus in Ward 5. As mentioned, accompanying me is our attorney, Sean Glenn of Ant Fox, and Rocketship has requested that the district issue up to $32 million in revenue bonds on our behalf. Infinity Community Prep, which we call RIC, opened in Fort Totten in the fall of 2020. And in the school year that just concluded, it served 306 children in grades pre-K 3 to 4. At full scale in 2025, the school expects to reach a maximum enrollment of about 550 students and will grow to grades pre-K 3 to 5. RIC embodies the three pillars of the Rocketship model excellently: personalized learning through tailoring instruction and pace to the needs of each student, talent development through investing in the growth of all of our teachers, and parent power, where we work to build the capacity of parents to be champions for their children's education. RIC is part of the National Rocketship Network, which is currently 23 campuses across the country, serving just over 10,000 students this year. 3 of those campuses, Legacy Prep, Infinity Prep, and Rise Academy, are in Washington, D.C. Our schools in the district are located in underserved communities and have a total enrollment of about 1,500 Rocketeers, of whom 92% are African-American, 77% qualify for free or reduced lunch, 13% are categorized as homeless, and 11% are categorized as students with disabilities. Rocketship's vision since our founding has been to eliminate the achievement gap in our lifetime, and our work in the district is key to that vision coming to life. In a recent study from Stanford University, Rocketship was called a gap-busting organization for the additional learning our students do relative to their peers. Each year, that study found Rocketship students make up the equivalent of 96 additional learning days in reading and 138 days in math each year. In the RIC communities, families are deeply engaged in their students' academic life and in the school community. Each fall, teachers visit the home of every student to show respect to families and to begin to build those strong relationships between home and school. Infinity Prep's teachers and employees also foster those deep connections with the community that they serve by living in that community. Of our 36 employees at that campus right now, 21 are district residents. And at full scale, we think total enrollment will rise to about 56, and we expect at least 34 district residents. So RIC, through the real estate affiliate Launchpad, will use the proceeds of these bonds to purchase the long-term leasehold interest in RIC's current campus at 5450 3rd Street Northeast and to pay related transaction costs. This transaction will substantially reduce the school's long-term operating costs, thus creating a much more sustainable future for Rocketship in the district. Again, we respectfully request that the district support the issuance of up to $32 million in tax-exempt bonds on our behalf. The bonds would, of course, not constitute a debt or a liability of the district, and they would be solely repaid by Rocketship and Launchpad Development 3 LLC, which is the entity that leases the campus from its owner. We also request, additionally, that this committee move our bill through markup before the council goes into recess in July. We understand that's a big ask and gives the committee only 2 weeks to work, but being on the meeting agenda for the full council approval in September gives us the flexibility to close these bonds sooner which is a real advantage in this volatile rate environment. With all that said, I'd love to answer any questions.
Thank you for your testimony. Just a couple of questions. In your testimony, you stated that the funds would be used to purchase a long-term leasehold interest in the current campus. Talk a little bit more about what that means and how much of the funds will go to that purchase, and what else, if anything, do you have planned for the remaining funds?
So we plan for 100%. To answer your second question first, 100% of the proceeds will be used for this acquisition, and then attorneys and bond fees and sort of strictly related transaction costs. So what we're going to do is buy out our land, who themselves have a ground lease on the property.
Can you repeat that? I'm sorry, it didn't come through clear on my end. Would you
No,
say-
no problem. The transaction will allow us to buy out our current landlord, who themselves have a ground lease on the underlying property. So we will assume the prime lease and be released from our current lease with our landlord who developed the property initially. And so that's the exchange, is we're getting the prime ground lease. Sean, anything you'd add there that I messed up?
Sure, if I may, council member, this is Sean Glenn, attorney for the charter school. The structure is the current landlord is the same landlord, ex-landlord for the other two rocket ship charter schools in the district. And the pricing on the buyout was part of the negotiation that was done back when the leases were put in place.
I was going to ask about the other sites. I know that the organization has used the district's revenue bond program a couple of times before, and those prior transactions were for those other two campuses or buildings?
Yes, sir, one each.
Okay. Any occasion to engage your ANC in the area of Ward 5, where this site is located? I believe it's 5450 3rd Street Northeast, and if so, how have those interactions gone?
This is Sean. I can take the first shot at that, Ben. Yes, we made a point of sending the ANC member and the council member for this ward copies of the application, and the Director of Legislative Affairs for Rocket Ship has been in direct contact with the office of the council member, Ward 5 council member.
Okay. And has the ANC provided any oral or written communication in terms of a position for or against?
No, sir, not to my knowledge.
And what's the time frame for this? You mentioned earlier, probably won't be able to get to it before recess, but you mentioned something about the fall. What's the time frame for you all?
So we have the option to buy the building beginning September 1st. And that's an option that lasts for 24 months. And after that, we're sort of locked into the current lease for the duration. And so we feel like sooner is better. Our goal is to close certainly by the end of the calendar year, to take advantage of relative rent interest rate stability, and to not wait around for risk of interest rates jumping by the end of the year.
Okay. All right. Well, I appreciate that. I don't have any additional questions for you all, but thank you for being with the committee this morning and providing testimony.
Thank you for taking the time. Really appreciate it.
Next, we're going to hear from our government witness, Gregory Johnson, project manager with the DC Revenue Bond Program within the Office of the Deputy Mayor for Planning and Economic Development. Good morning to you, and you can begin your testimony.
Good morning, Chairman McDuffie and members of the Committee on Business and Economic Development. I am Gregory Johnson, and I serve as a project manager in the DC Revenue Bond Enterprise Zone Program, a function within the Office of the Deputy Mayor for Planning and Economic Development. I am testifying today to request on behalf of Launchpad Development 3 DC LLC, that the council approve the issuance of the District of Columbia revenue bonds to Launchpad Development 3 DC LLC. The proposed revenue bond issuance will be in one or more series in an amount not to exceed $32 million. Launchpad Development 3 DC LLC has requested that the District of Columbia issue up to $32 million District of Columbia revenue bonds in one or more series to authorize and provide for the loan of the proceeds of the bonds to assist Launchpad Development 3 DC LLC in the financing, refinancing, or reimbursing of costs associated with an authorized project pursuant to Section 490 of the District of Columbia Home Rule Act. The bonds of issue will be secured by a general obligation of Launchpad Development 3 DC LLC and will be without recourse to the District of Columbia. Based upon the information set forth in the application, the Revenue Bond Program staff has determined that the proposed project complies with criteria for approval of a proposed financing transaction through the district's Revenue Bond Program. Additionally, the proposed project will promote education, trade, and commerce, enhance employment opportunities, and contribute to community betterment. This concludes my testimony, and I'm available to answer any questions that you may have. Thank you.
Thank you for your testimony, Mr. Johnson. Just a few questions to put this on the record. Have you explained to the applicant that these bonds are not the district's liabilities?
Yes,
Okay, and have you determined that the borrower is a qualified applicant under the applicable laws and requirements?
yes, sir.
And have you determined that the bonds will be used to finance a project that is authorized to receive funding through the district?
Yes, sir. Yes,
And is it your understanding that the borrower is able to service the debt resulting from the proposed financing?
yes.
Okay. And who did DEMPED use as counsel on this project?
For bond counsel, we're using Oric,
Darren
Sutcliffe, and Harrington, which is Darren Gliff.
Okay, all right. But when am I gonna hear y'all mention the CBE firm? Give me some clarity on that.
I mean, we've used, and this is William Liggins, Director of DC Revenue Bond Program. We've used our CBE firm, but to your point, we've come to where those contracts are ending, and we'll have an RFP on the street as soon as next week, if not by the end of this week, and I will make sure that that gets in your hand. We've already provided our contracting team with the list of the CBEs, all of the CBE bond firms that are currently registered with DSLBD. We received that list, and we'll provide you with the RFP as well, council members. So if you have any CBE firms or minority firms that you think are qualified, please get tagged to them, or you can have them contact me directly so we make sure that they receive that RFP.
I appreciate that, Ms. Liggins. Can you send us here at the committee that list that you received of CBE?
Sure, no
Firms?
problem. Mhm.
Perfect. What's your understanding of what the proposed timeline is to complete this transaction? You all have any concerns about the timeline, if we can get this done?
I mean, we want to get it clearly as, voted on as quickly as possible so that we can have them close and try to get the best interest rate possible. Whatever your timeline is, we'll try to work with it as quickly as possible.
Thank you for your testimony, Mr. Liggins and Mr. Johnson. Anything else you all like to add to the record before we close out this hearing?
No, sir. Thank you.
Thank you very much. And I forgot to swear you all in, too. I'll get you next time. I appreciate y'all's testimony this afternoon. I want to thank everybody who provided testimony on the measures before the committee today. And as a reminder, those interested in submitting written testimony for the record on any of the items that were heard before the committee today, I have until Friday, June 30th at 5 p.m. to do so. Submissions should be emailed to the committee at businesseconomicdevelopment@dccouncil.gov. Again, that email address is businesseconomicdevelopment@dccouncil.gov. There being no further business before the committee, This marks the end of today's public hearing. The time is now 11:24 a.m. That's 11:24 a.m. And this hearing is adjourned. Thank you.
Thank you.